start. In order to find a person guilty on circumstance trial, evidence, the circumstance or the circumstances must be such as would irresistibly lead to an inference of the guilt of the person charged with the offense. Stop. Thus, where in a disciplinary action against a public servant, the inference of guilty drawn by the tribunal from the circumstances is not the only irresistibly inference, then there is an error of law committed which may merit rectification by a writ court. Stop. Held on facts that the conclusions of the inquiring officer in a disciplinary action against a public servant were not based on evidence but on wrong inference drawn from evidence, and that he did not exhibit the proper sense of responsibility as a fact-finding tribunal in arriving at his conclusions, and therefore his report was quashed under Article 226. Stop. In the present appeal, it has been urged before us by Mr. Vishwanath Sastry on behalf of the appellants that the view taken by the High Court that the findings of the tribunal were not supported by any evidence is obviously incorrect, and that the High Court has in fact purported to reappreciate the evidence which it had no jurisdiction to do. Stop. It is common ground that in proceedings under Article 226 and 227, the High Court cannot sit in appeal over the findings recorded by competent tribunal in a departmental inquiry, so that if we are satisfied that in the present case the High Court has purported to reappreciate the evidence for itself, that would be outside its jurisdiction. Stop. It is also common ground that if it is shown that the impugned findings recorded by the administrative tribunal are not supported by any evidence, the High Court would be justified in setting aside the said findings. Stop. That is how the narrow question which falls for our decision in the present appeal is, was the High Court right in holding that there was no evidence on which the findings of the administrative tribunal could be sustained. Stop. Over.